Good morning. We're here for oral argument on Point 16 versus GTIS-HOV. It's our number CV24-0182. Each side has 20 minutes, as you know. Clock at the podium for your use. I'm trying to think what we have. We are at a full court today, so we've got everybody. So you may use whatever time you wish for rebuttal, but you have to keep your time yourself. Please begin.
Good morning. If it may please the court, my name is Kyle Israel from the law firm of Israel and Garrity. I'm here on behalf of Appellant Point 16 Community Association. We're here to discuss a couple of issues that relate to construction defect litigation. And in my case, in this case, we're talking about assignments from homeowners of accrued claims to their association, which is mandated by the CC&Rs drafted by the appellee developer to maintain the exteriors of units that are owned by those homeowners. The homeowners assigned those claims to the association so one entity could bring the claims, and because there was a challenge to implied warranty rights, which we're not talking about here today. The appellees raised an issue of the fact that in the purchase contracts with the homeowners, there is a non-assignment of contract rights provision because it refers to the credit rating of the homeowner, and obviously the developer, seller of the units doesn't want someone to step into the shoes of someone they thought they were selling the home to, and that person may not be able to close, that type of thing. So those are legitimate concerns. And they wanted to prevent the assignment of rights in a contract. That's something they can prevent under Restatement 317, as well as referred to in the Highland Village Partners case. But in this case, there was no assignment of contract rights. There was an assignment of accrued claims, post-loss claims.
What are the rights under the contract, the purchase contract? I looked at the contract, and it doesn't have what I would expect usually. So, okay, here are your rights. And so we know exactly what you're talking about. The builder is not part of this contract, correct?
Correct.
So what are the rights of the purchaser in this contract?
So the touchstone cause of action for construction defect claims is the implied warranty, which you don't usually see in the contract. And in fact, what you see in the contract is an attempt to waive that, which this court has struck down. This contract is no different. It includes a waiver of any and all implied warranties. It doesn't say, here's what you do get, other than it refers to a separate express warranty in an attached 210 warranty packet that a lot of developers use, and that's not what this claim was based on.
Well, and your claim, to your point, if this was just I sell you my house or a house that I have newly constructed, you would be an implied warranty of workmanship and habitability that is considered to be a contract term at that point implied into it. But here, so it would be a right under the contract. Here's kind of an interesting little twist, is that this was a pre-Zambrano contract, I take it, and it expressly disclaimed that implied warranty.
Correct.
So how could it be a right under the contract, or can it be a surviving right despite that language?
Well, the implied warranty has always been non-waivable. There was previous case law that it said it was not waivable, and then Zambrano raised the issue again, and at the Court of Appeals level as well as this level, the court said, no, it cannot be waived. So the implied warranty has existed all along in the face of these waiver attempts. So the implied warranty could not be waived away. Therefore, it existed. The homeowners suffered from stucco cracking, roof leaks, deck leaks, etc. Both sides confirmed, although differing extents, and therefore there was a breach of the implied warranty,
okay,
and that's what was assigned, that claim.
But moving back to the point that I guess I was getting at is what.
Sure.
So you agree then that a right under the purchase contract includes the implied warranty?
I don't, well, the implied warranty exists regardless of even a purchase contract, because for example, against a general contractor who had no contract with a developer, had no contract with the homeowners, it owes an implied warranty regardless of a contract with the homeowners under the Lofts case.
But you need a contract regardless, because it rises from.
Yeah, however sufficient that contract is, yes.
Okay.
I think our puzzlement, I think we have the same puzzlement.
Okay.
Agreed after Zambrano that it can't be waived, and you're saying that was true even before Zambrano. Can it, does it have to be assignable?
So the Highland Village Partners case says an implied warranty is assignable. The right to an implied warranty is assignable. And that case is back from 2008. And here again, we're not assigning rights, we're assigning a claim, so I don't want to get caught up in this assignable rights issue, which I didn't think was before the court. But in any event, yes, we have a case. Highland Village Partners allowed a seller of a commercial building to assign implied warranty rights to a buyer of that commercial building and overturned a trial court's decision that granted summary judgment saying you couldn't do it because it was a commercial context. So if you could do it in a commercial context, we know you could do it in a residential.
So suppose there's a company that goes around buying implied warranties and suing. Is it assigned? And that would certainly not advance the purposes of the implied warranty. Is it always assignable under any circumstance?
I've never seen any limitation put on it. I've never seen that situation occur. And in this case, they obligated the HOA to maintain the exteriors of these buildings, and they don't disagree that the homeowners have implied warranty rights because we have a separate arbitration going ever since the Court of Appeals held that the assignments were invalid, and I didn't want to wait for this to end. So they don't dispute the homeowners can bring the claims themselves, but the association ultimately has to maintain those exteriors. All they did was transfer the claims to their association, so the association could assert the claims, receive the compensation, make the repairs. This isn't a salacious situation where there's an assignment and someone's trying to play games or profit off of a legal trick. This is a justified and common sense transaction that was done in order to minimize the impact, the financial impact that the hundreds of thousands from their perspective, millions from our perspective, of repairs that are necessary out there.
Council, may I ask you a question about the CC&Rs?
Yes, sir.
How much weight should we give the fact that the developer in setting up the CC&Rs made the association responsible for the exteriors and the roof?
How much weight?
Yeah, I mean, is that a dispositive fact, or is that just part of the background facts here? Or should we somehow look at the relationship between the HOA and what the allegation that there was a breach of the implied warranty involves?
I don't think it's relevant to the framed questions, which is, can you assign a chosen action despite a non-assignment provision, in this context, homeowner to HOA. I don't know that the CC&Rs would factor into that, but I think it's more persuasive in this case because no one has disputed that provision is binding on the association.
Well, and that's why I asked that, because if there's any concern about who might come around and try to pick up implied warranty claims, if for some reason the relationship between the HOA and these particular claims, because the CC&R gave maintenance responsibility to the HOA, if that's one possible way of limiting the reach of a decision that said, well, under these facts and circumstances, it's implied that the HOA could do this because they had responsibility. Does that make any sense?
Yes, I understand what you're saying. You're saying limit the decision if there was an allowance for an assignment in this context, limit it to the situation where the HOA has some skin in the game, so to speak, by having a repair obligation. Therefore, it's receiving a cause of action that basically the association should rightly have in the first place because it's the one who's going to have to pay, even though it's the homeowners who pay the dues.
That's the next case.
Yes, exactly. But I don't think that limitation is going to be the last you'll hear of it if you do put it in place, because you're going to have HOAs on communities that might have 100 homes where they don't maintain the homes at all. But the homeowners don't want to hire individual lawyers or all be individual parties, but they want one association. The benefits of an association is strength in numbers, let that lead the way. Homeowners are going to want to make an assignment to the association for claims that they own and they maintain, but the association will agree to make the repairs once it receives the compensation. That's not our case, but it's something, if you're thinking about limitations, and I don't want to argue for the hypotheticals, but...
No, but I wanted to be able to understand that in this particular instance, we're considering the argument that, you know, these homeowners can assign their claim for a breach of implied warranty of habitability to an entity that otherwise isn't in privity with the builder or the vendor. I mean, even in Zambrano and other cases, you can establish, even in the instance in the commercial property and loss, we have the same similar scenario that we discussed in Zambrano, a subsequent purchaser. But at least it relates right back to an original builder-vendor, and then you have occupants, if you will. And we don't have that here. So if we acknowledge this, I want to understand what distinction are we making that comes up with a consistent principle that can be applied in other cases?
Well, the general principles under the restatements and the cases that we've cited is that in the face of a non-assignment provision, an accrued cause of action can be assigned, generally speaking. Okay, now if we want to limit that somehow because we're concerned about abuse, certainly to homeowners to an association where that association has taken on the obligation to utilize the funds recovered for the repairs that the homeowners would otherwise have to make. Here, the association would be making the repairs anyway. In my arbitration, I have homeowners suing individually for money to make repairs. Then once they receive it, they can't make them. They have to give the money to the association under some, they got to work that all out. It's cumbersome, and I'm not even sure why this is being fought here, because the claim doesn't go away. It just changes the identity of the claimant.
Well, just to be clear, so I got a little confused in some of your answers to Justice Montgomery's question.
It's not the first time I've confused someone.
But my understanding is that, at least your argument is that there is no assignment of the warranty itself. I mean, so nobody can take the warranty and go apply it to a new piece of property and do something with it. I thought your argument was you've assigned a post-defect claim for damages, which distinguishes it from a right under the contract. Is that correct?
Correct. Homeowners had to have a right that was violated, and in order to have a cause of action. So that there was a breach of the implied warranty that they owned by virtue of the defective construction that was discovered. That claim was now ripe. They could have asserted it themselves. They assigned it to the association as a cause of action. The association didn't get the right to warranties where they can call up and say, come and fix this. They received claims that they could then litigate, which they're doing.
The concern that Justice Bullock raised about some kind of entity going out buying up warranties, I'm unaware of any case that you have an assignment of a warranty that does not also go with the assignment usually of the warranty for the particular property. You can't just apply it to other properties. Is that right?
I've never heard of that happening either. That would be an assignment of an executory warranty right, where you can ask for something to be done, performance. You're asking for performance. And Section 317 says you can put in a non-assignment provision if you want in order to stop someone from assigning rights so that you're not dancing with a partner that you never chose, and it might enlarge your duties, your obligations, those kinds of things. Here, assignment of a claim, which all of the case law that I cited from all the different jurisdictions, as well as Section 322, which distinguishes assignment of claims, you're just changing the identity of the claimant. And other than that, they have to prove the same things, but they don't have any rights under the contract to demand performance.
Right. Isn't it then immaterial who the accrued claim is assigned to?
Yes.
I mean, it doesn't matter because the claim still exists and it can be asserted by the individual homeowner. So does it matter whether it's done for purposes of litigation efficiency here, having the HOA, which is a representative of the members of the community, or some other entity that's seeking to pursue these claims for profit, however that would work?
It is immaterial, and just keep in mind that if I was someone who knew what I know about construction defect litigation, I wouldn't go around buying claims because they're fraught with all kinds of trip hazards and speculative as to whether they're worth this much or that much, and whether I'm going to pay somebody for that, because they're not going to just give them up without me compensating them. I mean, that'd be a whole area that certainly is unexplored. I've never heard of it, and I'm not sure I would ever invest in something like that.
I have a question
Yes.
regarding some clarification that I hope you can provide. So the purchase agreement says that the rights of buyer hereunder may not be assigned without first obtaining the seller's written consent. The assignment, and there are a number of assignments in the record here by the individual homeowners, it says, I hereby assign to the association all rights to bring any and all claims. The use of that word rights there in that assignment, I mean, I understand you're saying it's the assignment of an accrued claim, but the assignment provision here talks about the assignment of all rights to bring accrued claims. So why isn't this assignment prohibited under the purchase agreement?
Because it doesn't say assignment of rights under the contract. It says the right to pursue claims. The right to pursue claims is to file a lawsuit, is to litigate the case, is to enforce the law with respect to the breach. It is not to ask the other side of a contract to perform or to do the things that someone who actually had contract rights could do. So that's never been raised, but it refers to the right to pursue a claim, and it refers to what the claims are. The claims are those outlined in the expert reports that identified all of the defects and the breaches of the implied warranty.
So the distinction really is the performance obligations, that's what the prohibition of assignment of claims is getting to in the purchase agreement when you're talking about performance obligations?
So the purchase agreement doesn't prohibit assignment of claims. It says assignment of rights. And the homeowners assigned the right to pursue claims. They assigned claims. So I want to make sure there's that distinction. So in the contract, they say don't assign your rights because of your credit rating, and we don't want to deal with someone else on that issue. They didn't assign their rights. They assigned claims, which is supported by, as I said before, the restatement by the Farmers v. Udall case, by the vast majority of case law. I didn't find a single case that said otherwise, that a non-assignment of rights provision would frustrate an assignment of claims, an accrued claim.
Could the purchase agreement prohibit or preclude the right to assign claims?
I think so, because I think the right to contract would allow for that. And this one doesn't. There's almost 2 minutes left, unless there's any other questions. I just want to quickly talk about the second question. That's really more just a factual issue. The general contractor who has an implied warranty obligation, regardless of contract, is not a party to this non-assignment provision. It's lumped in with the other appellee at both levels, not distinguished like we asked it to be. It should be left out of the first question, regardless of the answer to it.
Great.
Thank you.
Thank you.
Aaron Finter on behalf of the appellees GTIS-HOV Pointe 16 LLC, or the developer, and K-Hovanian Arizona Operations LLC, who we refer to as the builder. Not all claims are assignable. The key problem with the association's arguments, which this has existed at the trial court level and the Court of Appeals, is they argue that their claims are assignable without actually having identified any legal authority for that assignment. That's an issue that was raised by the Court of Appeals and I don't believe was addressed in any of the briefing before this court.
What about Highland Village Partners?
Highland Village Partners doesn't get us there. That case just identifies a couple of times where a claim could be assigned unless there is an issue where it's against public policy or there's an anti-assignment provision. So I don't think
didn't that case deal with new apartment complex and the original purchaser then assigned it to somebody he sold the apartment complex to, and the court said, yeah, you can assign those, you can assign the implied warranty under that circumstance. So why isn't that authority, at least for his position?
Because of a few reasons, including an issue that they addressed in the Farmers Udall case, which the association also cited, where they point out to the fact that there is in fact a statute in that case. It's ARS 2461, which evidenced the legislature's intent to allow the assignment of the claim. So I don't dispute that the legislature, by statute.
But that was in Farmers. That
In
wasn't
Farmers.
That wasn't Highland Park.
Correct.
So why is it Highland Park, which does deal with the same warranty that we're talking about here? Why doesn't that apply?
I would say it's distinguishable because it deals with an implied warranty on a commercial property between a purchaser and a subsequent purchaser. And no one's arguing here that you couldn't have the transfer of an implied warranty to a subsequent purchaser. But that's just not what we have here. We have that what they're trying to do is transfer the warranty to a non-owner of the property. That's, in my mind, one of the key issues here.
So how does that harm your client?
How does it harm my client?
Yes, I mean, it kind of kept hearkening back to some of the discussion that was had by Vice Chief Justice Lopez in his questioning, trying to get to the bottom of what harm, what contractual reason where you're trying to contract around to prevent this type of scenario. I mean, I can see a pre-escrow closing, assignment of rights, again, as I think it was phrased, you know, you want to dance with the one that you brought. You don't want to have a switch at the last minute with someone that you haven't vetted financially and such that you want to do business with. But once that's done, and under the contract, and there's a claim, it makes me wonder, okay, what's the difference then? A claim is a claim. You have a claim. Does it matter who brings the claim?
It does, and it goes to, I believe it was Justice Bullock's point of potential for abuse. If we can assign claims for construction defect to non-owners, there is a high probability that there will be an abuse. I mean, the whole point of the Purchaser Dwelling Act and the Homeowners Association Dwelling Act is not to increase claims, it was to reduce claims and get rid of vexatious litigation. And so if we are allowing non-owners to pursue those claims, I think it is inevitable that there will be abuse on those claims. So that's the real harm to my client, is that it will increase the number of claims, which is problematic, especially with the type of product that we're talking about in the Pointe 16 case, which is townhomes.
Counsel, can I ask you a question?
Yes.
I want to go back to what I was mentioning to your opposing counsel involving the CC&Rs. The developer set this up. The developer set up where it created an HOA that everyone who buys a townhome has to be a part of, and then assign responsibility for maintenance of these particular exterior walls and the roofs to the HOA. So related to the Chief Justice's question, if all this occurs within a relationship among parties that the developer set up in the first place, and we're not looking at an assignment of claims to someone who's unrelated to either the association itself and or the original contract, what's the harm?
I mean, I think the harm to my client is, again, even if it is the association, I think actually the Pointe 16 is a good example of this. When the association brought the claims, how many owners were involved? 67, everybody. Once the claims were dismissed, and after the appeal was denied, how many of the homeowners asserted those claims? The answer is 34, so roughly half of the homeowners were actually interested in pursuing those claims.
Well, let me ask you a question about that, because I mean, that's a bit curious. Because if I live in one of these townhomes, I have a shared roof. I don't have my own roof. So what if my part of the roof is fine? I don't care. I don't care about my neighbor. I'm not very neighborly. So why would I want to be involved in a lawsuit and have to have whatever hassle it is? Just let them deal with it.
Yeah, and I think that highlights one of the issues here, which is, in this case, as the trial court noted, we have an association that was attempting to bring claims for all of the homeowners when they didn't actually have assignments from all. They had assignments from most of the homeowners, but not all the homeowners. So if you were the person who was not affected by some construction defect, you're effectively paying a small portion of the monies that's going by the association to fund that litigation. did you get consent? Because that's my other concern with the association pursuing these claims, is there's protections under both the CC&Rs and Arizona statutes under ARS 33-2002 that require notice and meetings before the association is spending money on behalf of perhaps less than all the homeowners. And to me, there is a chance that this is maybe an effort to kind of circumvent some of those requirements and potentially allow the association to get around that notice requirement where money is being used by all of the owners to fund issues related to only some of the owners.
Now, under their purchase contract, you prohibit the assignment of rights under the contract unless you consent, correct? But you can't withhold that consent unreasonably. So and it makes me think, well, in what circumstances would it be reasonable to grant that consent? It seems like signing multiple claims that are of the same nature to one entity that has the HOA that has some connection and isn't one of these roving purchasers of warranty claims might make some sense. Could you reasonably withhold your consent to such an assignment?
Reasonably, perhaps not, but you'd have the contractual right, I would assume. Again, I mean, that kind of goes to, I think, one of the association's argument, which was judicial economy, that somehow this would be more difficult or more time-consuming if it was pursued by the owners instead of the association. And again, point 16 is the perfect example of how that is not true. That, in fact, had they originally brought these claims, the owners, instead of the association, in an arbitration proceeding, these claims would have been resolved 2 years ago. We wouldn't be here today. And in fact, we have an arbitration hearing on these same claims, I believe it's in August. And so, I don't know, I have no knowledge of this court schedule or when the ruling will be issued, but these very same claims will be decided in an arbitration proceeding as to 34 of the homeowners in August of this year. So I would submit that had they properly brought those claims almost 3 years ago in an arbitration, and again, they've done it in a single arbitration with the same attorney. So from a judicial economy standpoint, there was no advantage to the association bringing those claims on their behalf. It's effectively the same. Well, actually, it's worse. Again, they would have had those claims resolved through arbitration 2 years ago.
I think it would be a different matter if there was a pure anti-assignment clause here. But there isn't. There's prefatory language that says, in view of the credit qualifications processing and other personal matters considered hereunder. Don't we have to, in interpreting in the contract without looking at any other principles or the second restatement or anything like that, don't we interpret the language of the anti-assignment provision in light of that prefatory language?
I mean, I think that would be fair. I think my real issue is that all of the case law cited by the association from across the United States where they try to distinguish between rights and claims, I mean, if I were to kind of summarize all those down, they're breach of contract claims for money damages, which just isn't what we have here. This is a claim, again, I likened it more to the personal injury claims, which are non-assignable, because absent, an injury to your person, I would submit that a potential defect to the interior of your property, which is what we had in this case, I mean, it doesn't get much more personal than that. And assigning that claim to somebody else leads to some just, I guess, strange practical considerations, which is someone else allowing, these are construction defect cases, 20 or 30 people to the interior of your house to examine things, and they're experts and do testing when they're not the owner of the property. I think it leads to kind of a bizarre result if we allow the association to do so. And the other reason I think that those claims for just money damages generally don't make sense is just the fact that, well, in this case, the CC&Rs limit the remedies and damages. If a claimant is successful, what they get is the repair or replacement. The only right or remedy the claimant may have is the right to have the alleged defect repaired and or replaced by the builder. So that's in the CC&R. So this isn't a money damages claim. If the well, it was the association, now the owners. If the owners are successful, what they get is the defects repaired. And so how do you assign that to somebody who doesn't own the property? Again, it results in sort of a bizarre situation where somebody else is bringing an action to repair, say, your roof or your stucco on your house. Just doesn't make any sense to me why that assignment would take place. And if there is an assignment that's permissible to the association who is a non-owner of the house, I understand the association's argument, oh, but we have a right, a duty, or an obligation to maintain. Well, maintain is not the same as to repair a construction defect. For example, maybe the stucco's too thin on the wall, but otherwise it's cosmetically, aesthetically just fine. Does the association have any rights or obligation to do anything? No, they don't. And so, I don't liken those two things. A maintenance obligation is not the same as repairing a construction defect. And I think that, you can't say in this case that it makes sense to assign that construction defect claim to an association who doesn't actually have an obligation to correct a construction defect.
I have a question. Let's move on to the other issue in terms of the relationship between the builder and the homeowners. You argue in your brief that the implied warranty claim the association is seeking to assert against the builder is tied directly to and would not exist but for the purchase contracts. And you argue that to conclude that the anti-assignment provision of the purchase contract should bind the association from assigning its claims to the builder, even though the builder is not part of that contract. But doesn't the builder owe the homeowners an implied warranty simply by virtue of having constructed the home, regardless of the purchase contract?
Yeah, my argument on that, yes, is the answer to your question. My argument on that, the association argues that, the builder is not a party to the contract. Well, the builder is actually expressly, the builder is identified in the contract. It says who's going to be building the home and identifies who the builder is. Is the builder a signatory to that contract? No. But my argument is certainly that they're a third-party beneficiary since they're specifically identified in the purchase contract as being the one to build the home, and that they should get the benefits of being the third-party beneficiary. And if they're going to be held liable to an implied warranty that arises under the purchase contract, if you get the liability, you should get the benefit that arises under that contract as well, is my argument, which would in this case be the anti-assignment provision. And you could argue also on that point, judicial economy. Depending on the court's ruling on the assignment issue, you could end up with a case. So if the assignment to the association is not permitted as to the developer, but it is permitted as to the builder because they are not a signatory to the contract, I think, we could end up with the same claims being litigated in multiple forums. So you have the judicial economy and potential for inconsistent verdicts could be an issue if that was the court's ruling. Just a few more points, and I've touched on it already, but just kind of the practical considerations. If it's permissible to assign the claims to the association who is not an owner of the property, then what would prevent the assignment of the claims to another non-owner of the property? And that is a big concern to my client. And the issue there is, I could see all kinds of potential. We could take an example of what if the purchase contract automatically, if this court were to find that assignments are permissible to the association, what if the purchase contract or another contract in connection with the purchase automatically assigns your construction defect claims to that association? Well, I could see some problems with that initially because who's in control of the association initially? The declarant. Who's the declarant? My client who's building the property. Why couldn't we then assign those claims then from the association back to the builder? The problem with granting the assignment is I think it opens the door to a lot of problems that don't currently exist and won't exist as long as we continue to keep the law the same as it's been for 45 years, which is there have been no assignments of these claims to a non-owner. The only extension thus far is to a subsequent purchaser, which makes absolute sense. That I would never argue that doesn't make sense. What doesn't make sense to me is opening that up to the potential where someone who has no ownership in that property now has that claim. Because how do those claims work? Well, first, you have to send out a notice and give the contractor the opportunity to repair someone else's property. Well, that doesn't quite make sense. And then if there isn't a repair, then someone else needs to come out and inspect, and ultimately there'll be a lawsuit, not in this case, but in a general case for damages. Well, what's to say that those damages then go to pay for the repairs to the property? I mean, I guess you'd have to be very careful on your assignment, which the homeowners in Point 16 weren't very careful, because if you read the assignment language, the association doesn't have an obligation to fix anything. It's up to them to decide to do, at the conclusion of the lawsuit, what to do. And so,
But isn't that the problem between the association and the homeowners? I mean, I'm trying to think how that's your clients. You raise a good issue, but I would just think that any assignment should, like any assignment, you would give those kinds of details, that they'll use the money for repairs, for example.
yeah, I don't know that it's an issue specifically for my client. I raise it as a public policy issue, that I think it's dangerous to give somebody that ability because there is a potential for abuse.
Well,
And
counsel, let me ask you a question about that, and this kind of gets back to, again, when I was raising with your opposing counsel, that in this particular instance where the association does have responsibility for the exterior walls and the roofs, tying any responsibility to utilize those proceeds to carry out their responsibility assigned to them on the CC&Rs, I see a potential linkage there. And to the earlier point you were making about, does the HOA, can they really go in and do the inspection and go inside of the units? I think the CC&R gives them the ability to do that. So if we confine ourselves to the universe of the CC&Rs, if in the first instance, say the assignment of claims for bad stucco, well, if the stucco isn't the right thickness and over a period of time the chicken wire shows through the mesh, well, isn't that then the HOA's responsibility to repair that under the CC&Rs? I see that as one possible way of confining this to the particular relationship here.
Potentially, but there's also then the case where, I mean, where do the monies come from to address maintenance issues? They come from the reserves that are funded by the builder and from the assessments. That's where the money comes from typically. My concern is, and the potential abuse that I could see, is in a case where money damages are possible, an association going out and trying to get a multi-million-dollar massive construction defect judgment that really doesn't actually go to fix the problems. It goes to fund additional reserves, which they can then use for whatever. And maybe that goes in some small part to fix some of the issues, but it doesn't go directly to fix the actual issues. And again, I come back to, I mean, yeah, we're talking about the assignment of implied warranty claims, but these are claims that have to be made under the Purchaser Dwelling Act and the Homeowners Association Dwelling Act, which are statutes designed to limit the claims. And they're designed to make sure that the defects are corrected. And there is no guarantee, once we open this door to assignments, that the defects will be corrected.
How would the under that act that you just mentioned, you said that getting the defects corrected, it also includes in the definition of the dwelling action, and definition of dwelling includes property owned, jointly owned by all the homeowners, not the HOA directly. But it seems like the statute contemplates that an action can be filed by the HOA. Doesn't that contemplate then some type of an assignment? What other action would the HOA be filing for property jointly owned by the homeowners?
Well, I mean, property jointly owned by the homeowners, in my book, is common areas.
Right.
And so, no, I don't, so who owns the common areas? The association holds title to those. So I don't believe there would be a need for an assignment in those situations.
No, in a situation where the homeowners themselves jointly own and the HOA does not own, but yet the act seems to contemplate that actions will be filed by the HOA. So I'm asking, well, what would the cause of action be without an assignment?
I mean, if the statute gives the association that authority to bring it, then you're really bringing it. I guess that you don't need an assignment in that case if the statute is giving that authority directly to the association.
And that's a segue to the next case, so.
I have one
Thank
quick
you.
question.
Oh, one,
I have one question for you. You've laid out, you've shared your concerns, and I understand they're well-reasoned, and so I take them in that vein. But if we were to disagree with your position in this case, prospectively, couldn't you avoid all of these problems by simply recrafting the anti-assignment provision to preclude the assignment of claims? I understood Mr. Israel to concede that that was possible, just as a contractual matter.
I think it would depend on the court's ruling, I guess, would be is my answer to that question. If the court's ruling is that, hey, this isn't like a personal injury claim, these claims are, generally speaking, freely assignable unless, there is the correct, then yes, maybe. But if the court's position is these claims are freely assignable, then I don't see how that would help us.
well, now I have a follow-up then. Because it strikes me of those kinds of, and I know that's not the issue before us, but it strikes me if claims are freely assignable in these kinds of contexts, then wouldn't the insurance companies have done that years ago to prevent Morse agreements and all of those things that happen all the time? So I wonder, are you aware of any authority out there saying that, no, you can't prohibit assignment of claims?
Not in the state of Arizona. In the state of Arizona, as far as I am aware, it is never, there's no court of appeals or Supreme Court decision that I am aware of on that issue.
Okay, thank you so much. All right, Mr. Israel, you have a couple minutes.
Mr. Israel, you finished with question 2, which you raised in your petition, so presumably you want us to address that. And I didn't find your brief or your parting comments really helpful on that. Mr. Finter said if you are obligated, even though you're not a signatory to the contract, why wouldn't you also be able to reap the benefits?
First of all, they've never said they were a third-party beneficiary. Today's the first time. I would have briefed that, and the court knows you have to be named expressly as a beneficiary to be a third-party beneficiary. They're not. They're not a signatory either. They're just a fill-in-the-blank general contractor that they chose.
They're obligated. They're unquestionably under the implied warranty.
Correct.
So why are they not, as a matter of however they are obligated, don't they have reciprocal benefits as well, regardless of whether they're a third-party beneficiary?
They're not parties to the contract where they could enforce other provisions, express provisions in the contract. We could have sued just the general contractor under implied warranty. This whole written contract never would have been an issue in that situation. They're not a third-party beneficiary to it. They don't automatically become a party to it by virtue of the fact that they owe an implied warranty. So, no, I don't believe so. But in any event, since they're separate and apart, there could be a decision where if you decide that we can't assign claims, notwithstanding Farmers v. Udall, notwithstanding Section 322, notwithstanding with the interpretation of the contract itself is aimed at rights, not claims. It's concerned with financial position, not later litigation. All the things they could have talked about and could have sought to address when they wrote the contract, they didn't. And now they're arguing to apply it in that way. I was going to address one more thing, but I think I'm out of time. So
Thank you.
Thank
But
you
it
very
was a
much.
good crescendo anyway.
That was a good crescendo. All right, I thank all counsel for their briefing and argument today. I will take the matter under advisement and issue a decision in due course. Meanwhile, we will recess to allow the next case to come forward.